Hi, my name is Mike Roberts. I'm an attorney with the Cohen Law Group here in Pittsburgh, and I'm here to talk to you today about the FCC's third report and order and declaratory ruling and how it affects municipalities in Pennsylvania and beyond. As you may know, on September 27th, 2018, the FCC issued its third report and order and declaratory ruling. And this order was by far the most drastic change in the wireless arena since the Telecommunications Act of 1996. And as such, it's important that your municipality understand what is contained within this order, what requirements you will be facing when it comes to wireless regulation, as well as what you should be seeking to do as a municipality in order to bring your current code and your current municipal procedures into compliance with the requirements of the FCC. So first, it's important to go over what exactly is included in the FCC's order, and we will go into more detail about each later in the video. Primarily what the order does is establishes a newly defined term, the small wireless facility. This essentially will be any facilities that you're seeing in your public rights of way for the foreseeable future. The order also creates new shot clocks for the review of applications for small wireless facilities. It limits fees to cost recovery and details what are known as presumptively reasonable fee ceilings for small wireless facilities, and it establishes new requirements for aesthetic standards relating to small wireless facilities. Now, these first three portions of the order took effect on January 14th, 2019. The aesthetic standards requirements, which we will discuss later in the video, go into effect on April 15th, 2019. So the first question we naturally have to answer with respect to the order is, what is a small wireless facility? A small wireless facility is defined as a facility where the structure on which the antenna facilities are mounted is either 50 feet or less in height, is no more than 10% taller than other adjacent structures, and this would typically be nearby utility poles, or where the structure is not extended to a height of more than 50 feet or by more than 10% above its pre-existing height as the result of the co-location of a new antenna facility, and that would be attaching an antenna to an existing structure. Also, each antenna associated with the deployment can be no more than 3 cubic feet in volume, and all antenna equipment associated with the facility, excluding the antenna itself, can be cumulatively no more than 28 cubic feet in volume. So as mentioned, this will be essentially any facility that you'll see going in the public rights of way, although you may see applications for small wireless facilities outside of the public rights of way as well. So any facility that meets the definition of a small wireless facility has to comply with a few major points that are established by the order. The first is a new set of shot clocks for small wireless facilities. You may be familiar with the shot clocks of the 2009 order. These have been altered specifically for small wireless facilities in the third reported order. So first, co-located small wireless facilities. This will be any antenna being attached to an existing structure, whether or not an antenna is already located on that structure. The shot clock for such facilities is 60 days. For small wireless facilities that require the installation of a new pole, the shot clock is 90 days. For incomplete applications, your municipality must notify the provider within 10 days that an application is incomplete, and this will toll the shot clock once. After this initial notice, any incomplete application thereafter does not toll the shot clock, and it will continue to run as the supplemental materials are submitted. An important distinction between these shot clocks and those of the 2009 order is that for small wireless facilities, all approvals, permitting, and agreement negotiation has to be completed within the shot clock time frame, whereas for the 2009 shot clocks, it only requires action on the application within the time frame established. The remedy for a violation of these shot clocks is expedited injunctive relief, which again is a departure from the 2009 shot clocks, which had a deemed approval remedy. So the applicant here would file for injunctive relief in federal court and obtain an order forcing your municipality to approve the application. Moving on to fees, the order states that fees must be a reasonable approximation of a municipality's costs and that those costs themselves must be reasonable. In order to show what the FCC believes to be a reasonable fee, the order details presumptively reasonable fee ceilings. And these are divided into initial application fees and recurring annual fees. For initial application fees, a municipality may charge $500 for a single application, which covers up to 5 co-located antennas. So for anywhere from 1 to 5 antennas in a single application, your municipality can charge $500 total. For each antenna included on a single application thereafter, you can charge an additional $100 per. For a small wireless facility that requires the installation of a new pole, the application fee is $1,000 in terms of a presumptively reasonable fee ceiling. For recurring fees, these will be your annual fees for use of the rights-of-way or for attachment to municipal facilities. You are permitted to charge a fee of $270 per site per year, and that is all-inclusive. So for both fees for use of the rights-of-way and for attachment, the total presumptively reasonable fee ceiling is $270. Now, the FCC does state that local governments may exceed these fee ceilings, but only in very narrow circumstances, and it is crucial that your municipality conduct a defensible cost study in order to support any such excess in the fees that you charge. Moving on to aesthetic requirements, and remember this is the portion of the order that does not take effect until April 15th. The order states that all aesthetic requirements for small wireless facilities must be reasonable. They must be no more burdensome than those applied to other types of infrastructure deployments, which we see as being other wireless providers, and they must be objective and published in advance. What this means is that it's important to have very clear aesthetic requirements for small wireless facilities, as if you don't, providers will be able to use the language of the order to invalidate or avoid any unclear aesthetic requirements that you have. In order to comply with this portion of the order, it's crucial that your municipality either amend its wireless facilities ordinance to include comprehensive design standards for small wireless facilities, or to establish a separate design manual, which would be a standalone document from your municipal code that details, again, the aesthetic requirements for small wireless facilities. And you can include images, you can include specific standards for antenna placement or design, for the type of support structure that can be installed. There's considerable latitude in what your municipality is allowed to impose as a design requirement, but the crucial point is that it's absolutely necessary that you have these published in advance in some fashion, and that the requirements themselves be objective and not subject to too much interpretation. So with all of this in mind, the question that naturally arises is, what should our municipality do in order to comply with the requirements of this most recent FCC order? Our firm's proposed course of action is that your municipality either draft a new ordinance or amend your current ordinance, depending on what you have in place, to achieve a number of goals as a result of both the FCC order as well as the changing landscape of wireless facilities deployment. So your first goal should be to create comprehensive construction and design standards for small wireless facilities. These are a completely newly defined term, a new type of facility that is subject now to a completely different regulatory landscape than other wireless facilities. So it's crucial that you single these out within your code. It's also important that you establish application and review procedures for small wireless facilities in order to ensure that review of applications is done efficiently and that your municipality can comply with the shot clocks established by the FCC. We also suggest that you amend or create a fee schedule, either by using the new FCC fee ceilings or conducting an independent cost study. And this may be simply amending the fee schedule you currently have in place to reflect the fee ceilings for small wireless facilities, but nonetheless, it's important that you revisit your fee schedule to ensure that the fees are compliant with the requirements of the order. You should also clarify what type of applications are required for each type of wireless facility, as well as the applicable shot clocks and procedures for each. And finally, moving beyond your code, you should consider any required supplemental documentation for wireless facilities generally, whether that be right-of-way use agreements, pole attachment agreements, and the like, to ensure that they too are compliant with the requirements of the FCC, as well as that they can be negotiated or executed efficiently, again to ensure compliance with the shot clock timeframes. The bottom line is that the field of wireless facilities management is changing, and it's important to amend your existing wireless facilities ordinance to incorporate these recent regulatory changes, to protect your residents, address new technologies in the field of wireless service, and most importantly, to strike a balance between meeting the need for wireless broadband service, which is a very real need, and preserving the character of your community. If you have any questions at all, please feel free to reach out to us at the Cohen Law Group at the following contact information.